webinar is about to begin. We will be muting your phones for the program.
Good morning, good afternoon, or good evening, depending upon where in the world you may be. This is Doug Isenberg from the GigaLaw firm, and I want to welcome everybody to our webinar today on how to dispute a .us domain name. I will be welcoming in just a minute my co-panelist, Renee Fossen, the Director of Arbitration from the Forum, to our program, where we will talk about the two important .us dispute policies. That is the usDRP, which allows a trademark owner to seek the transfer of a problematic domain name, and the usRS, which allows a trademark owner to seek the temporary suspension of a problematic domain name. But before we get into the heart of our program, I just want to hand the microphone over to Carol Todd Thomas for a couple of housekeeping items.
Thank you, Doug. My name is Carol Todd Thomas, Client Services Coordinator with the GigaLaw firm, and I will be facilitating today's webinar. As Doug mentioned, we just need to review a few housekeeping items. We will not be taking questions during this program, but we will be answering questions that you submitted in advance. If you have technical difficulties or cannot see or hear the program, please notify us using the chat box on the screen in the webinar software. We will be sending out evaluation forms immediately after today's program, and we greatly appreciate your response. You will have access to the slides available from today's program after completing the evaluation. This program will be recorded for later replay on the GigaLaw website. Please note that this webinar is providing general information only, and no content should be construed as legal advice or that an attorney-client privilege and relationship has been formed by this presentation. If you wish to stay informed about domain disputes and internet law, Doug Isenberg publishes a daily news alert and weekly blog. You may sign up at www.gigalaw.com/subscribe. We can now begin our program. Today's speakers are Doug Isenberg of the GigaLaw firm and Renee Fossen, Director of Arbitration with the Forum. Doug Isenberg is the founder of the GigaLaw firm and has been called a whiz on all things to do with internet law and domain names and an international authority on internet law. He has filed the largest domain name dispute ever, assisted clients with seven-figure domain name purchases and sales, and regularly helps clients enforce their rights via important legal tools and advice. Doug's legal practice has focused on internet law and domain name disputes for more than 2 decades. And he serves as an arbitrator or panelist for the leading domain name dispute providers, including the Forum and the World Intellectual Property Organization, known as WIPO. His GigaLaw blog has received numerous honors and is listed in the top 100 by the ABA Journal. Renee Fossen is the Director of Arbitration for Forum. Renee earned her Juris Doctorate from Hamline University School of Law in St. Paul, Minnesota. Prior to joining Forum, Renee was in private practice and managed large, complex litigation matters. She has significant experience in all aspects of litigation, including jury trials, bench trials, local and international arbitrations, and mediations. I am now turning the program over to our first speaker, Doug Isenberg.
Great, thanks, Carol. So to begin, we're obviously going to focus today on the .us top-level domain, and some may be familiar with the .us ccTLD, and some may not. Some of us are just much more familiar with .com, .net, and .org, and so forth. So before we get into the legal issues, we just wanted to provide a little bit of background on what is .us, where did it come from, how important and popular, and for that matter, problematic is it? And so there are really a few different categories of top-level domains. Most of us are familiar with what are referred to as the generic top-level domains, or TLDs. And surprisingly, there are now more than 1,200 of these. Surely nobody can name all of them without a cheat sheet, but there's a small group of what are often referred to as the legacy GTLDs, such as the .com, .net, .org, and a handful of others that have been around almost as long as the internet itself for many of them. There's also a smaller group of what are sometimes referred to as restricted GTLDs, those that have certain criteria or historically have had certain criteria around whether a registrant is eligible, such as .name and .pro. And then the largest group of the generic top-level domains are those that have been approved by ICANN, the Internet Corporation for Assigned Names and Numbers, in recent years, well over 1,000 of them, some of which have gained a little bit of traction, many of which have not. These include such new GTLDs as .xyz, .email, .nyc, and many, many others. There's a second group of top-level domains of about only 15 that are referred to as sponsored TLDs, such as .edu, which is available only for certain educational institutions that meet the registration criteria, .gov, which is available only for use by certain governmental entities in the United States, .int for certain international organizations, and so forth. And then there's a very large group, as we get to the third category of top-level domains, that includes what we're going to focus on today in this webinar, and that's .us. These are commonly referred to as ccTLDs, or country code top-level domains. There are about 311 of them. Just about every country on the planet has its own two-letter country code top-level domain, such as .us for the United States, .fr for France, .uk for the United Kingdom, .de for Germany, and so forth. Interestingly, some of the countries around the world have chosen not necessarily to use their own ccTLD for geographic purposes, that is to identify entities that are within their own country, but instead have opened them up for certain marketing purposes because of the appeal associated with their particular two-letter country code. So, for example, the country of Tuvalu, which is identified by the ccTLD of .tv, has made its country code available for use by creators, television show operators, producers, and so forth, and therefore the .tv country code is rather popular for television programs. You can see a few others here, including .md, which is the country code for Moldavia, but is also marketed for use by medical doctors here in the United States. Now, interestingly, when it comes to domain name disputes, there is no uniformity among the country code operators, registry operators, as to how domain name disputes are resolved. Many of the ccTLDs have subscribed to the sort of big domain name dispute policy, that is the usDRP that many of you are probably familiar with, the Uniform Domain Name Dispute Resolution Policy. So in some ccTLDs, you can resolve a dispute under the usDRP. That is not true with respect to .us. There's sort of a second category of ccTLD disputes, and those that have adopted a dispute policy that is modeled on the usDRP. So it is very similar, but not identical to the usDRP. And that is true with respect to .us. And then finally, although we won't be talking about it during today's webinar, there are two other sort of categories of ccTLD dispute policies or ways of resolving ccTLD disputes. Some particular country codes like .uk have adopted their own dispute policy that is totally different from the usDRP, but is nevertheless sort of administrative process for resolving a domain name dispute. And then there are some countries that simply have not adopted a domain name dispute policy at all, and the only option in those countries is simply to go to court. So .us in the United States is operated by a company with which many of you may be familiar, the registry operator known as Neustar, a public company based in Virginia. Neustar holds itself out as the world's largest provider of digital naming services and actually acts as a registry operator not just for .us but also for the .biz top-level domain, and thanks to ICANN's recent expansion of new GTLDs, its own .neustar top-level domain. And Neustar itself, as it said, supported about 200 or so .brand pioneers. Those are companies that applied for their own top-level domains during the recent ICANN process. So this is the Neustar homepage for the .us country code top-level domain. And what's interesting is the .us top-level domain is has some eligibility criteria attached to it. So unlike a .com, for example, where essentially any person or entity anywhere in the world may register a domain name within the .com space, a domain name registrant for a .us domain is required to meet certain eligibility criteria. As you can see on the screen here, there are 3 categories that apply. So a domain name registrant must be one of the following: either number 1, a natural person, which is defined as a U.S. citizen or a citizen or permanent resident of the U.S., or simply a person whose primary place of residence is in the United States. The second category of domain name registrants that are eligible to register a .us domain name are United States entities or organizations, that is, those that are either incorporated in the United States or are otherwise organized or constituted under the laws of a state of the United States. And this includes, interestingly, federal, state, and local governments, which sometimes register and use .us domain names themselves. And then finally, the third category of entities that are eligible to register a .us domain name are certain foreign entities or organizations if they have what is referred to as a bona fide presence in the United States. Now, the .us registration is growing in popularity, but still a very small portion of all the top level of all the domain names that are registered. There are, as of a recent Neustar report, about 2.1 million total U.S. domain names under management. This represents a tiny fraction, less than 1%, of all domain name registrations worldwide. As you can see, there are more than 329 million domain name registrations across all top-level domain names worldwide, and the largest portion of those, not surprisingly, are .com domain names, nearly 127 million of those. Interestingly, for those who follow the new GTLDs, that is that group of 1,000 or so that have been added by ICANN in recent years, there are about 25 million new GTLD registrations, and then just by way of comparison, the largest ccTLD, the largest country code top-level domain in which registrations exist, is .cn, the country code for China. So an entity, a person, or a business that wants to register a .us domain name can go to an approved registrar. There are, as you can see, about 151 of these. They include such large and well-known registrars as Network Solutions, Enom, GoDaddy, 1&1, and so forth. This is a small portion of the total number of ICANN accredited registrars. There are about 2,900 of those. But nevertheless, there is certainly competition for where a person or entity can go to register a .us domain name. And registrations have been increasing significantly since the late part of 2016, as you can see from this slide here, which really shows the total number of domain name registrations over the past year and a half or so. There's been a recent significant increase in the total number of .us domain name registrations. It's perhaps a little bit of a mystery as to why that is the case and whether it will be sustained. It could be simply a new focus of interest on top-level domain names in particular, perhaps as a result of the new GTLD program or other marketing efforts. And this next slide shows sort of a pattern of what's happening, that is how we're seeing this total number of increase As you can see here, this chart tracks an increase in the total number of registrations, as well as what's happening with .us renewals and .us deletions. So all that so far is really a bit of background just on what .us is and how big it is. Frankly, as you'll hear as we go through the presentation, and as Renee will expand on in a few moments, there are really, relatively speaking, few .us disputes. But there are two significant .us dispute policies, and that's really what we want to talk about today. The first is the usDRP, or the US Dispute Resolution Policy. This, as I said at the outset, is the dispute policy that allows a trademark owner to seek the transfer to it of a problematic domain name. It is very similar to the udRP. I'll provide the details in just a minute. And then after that, I'll talk about the usRS, which is the US Rapid Suspension System, which is modeled after the usRS, which allows a domain name, a trademark owner rather, to seek the temporary suspension of a problematic .us domain name. So we've only seen about 610 cases under the usDRP since it went into effect in 2002. By comparison, there have been literally tens of thousands of udRP decisions since the late 90s when the udRP went into effect. Again, just to be clear, the udRP applies to .com and many of the other top-level domains. It is the policy on which the usDRP is modeled. But if you want to seek the transfer of a domain name that is a .us, you need to file a complaint under the usDRP, and Renee will walk us through the process for actually filing a complaint in just a minute. So as I said, you can seek, if you are a trademark owner, the transfer of a problematic .us domain name. You could also request cancellation of a .us domain name. That's not a popular request, but it's certainly one that's available to a trademark owner. There are three tests that a trademark owner must meet in its usDRP complaint. As you can see, they're outlined here on the screen. Number one, the trademark owner has to show that the domain name is identical or confusingly similar to a trademark or service mark in which it has rights. Number two, you have to show that the respondent, that is the registrant of the domain name, has no rights or legitimate interests in respect of it. And number three, the trademark owner has to show that the disputed domain name has been registered in bad faith or is being used in bad faith. And that word "or" is key here. That's really the significant difference with the udRP itself. I'll elaborate on that in just a moment. But like the udRP, all usDRP complaints are filed online, and it is intended to be an expedited process. Typically, it takes about 2 months from the time of filing a usDRP complaint until the time of getting a decision. Because there are no in-person hearings, no discovery, no briefs, no motions. The only documents that are typically filed are a complaint and perhaps a response. All usDRP disputes are decided by either a 1- or 3-member panel, and a usDRP proceeding is probably the most common way in which a .us dispute is resolved, but court proceedings are nevertheless always available to the parties at any time, including to a losing domain name registrant who can go to court even after a decision has been notified. There's one potential complication that arises in the course of a usDRP proceeding, or that theoretically could arise, that does not arise in the course of a udRP proceeding, and that is what would happen if there is a trademark owner who prevails in a usDRP case, that is, obtains a decision ordering the transfer of a .us domain name, but as it turns out, the trademark owner is not an eligible .us applicant or registrant. This is not entirely theoretical, because there are some other ccTLDs that have similar issues, that is eligibility criteria and dispute policies. Canada.ca is one, for example. But frankly, the usDRP is silent on this issue, and instead it would be up to yet another type of dispute, which is really outside the scope of this webinar. That's the usTLD nexus dispute policy. This presumably is a policy that might lead to a complaint in that type of a situation. It allows a third party to actually file a complaint for non-compliance. That is, if it believes that a .us registrant is not an eligible registrant, and a decision under that nexus dispute policy can actually lead to cancellation of a .us domain name. Not much, frankly, is known about that policy because the decisions are not published. So this slide shows some of the similarities and differences between the usDRP, which is very familiar to those of us who practice in this area, and the usDRP, which, as I said, is just not that common. The biggest difference, as I said a moment ago, is on the third element, the third substantive element of a usDRP complaint. Under the usDRP, you have to show that a domain name was registered and is being used in bad faith. And there are plenty of usDRP decisions in which complainants have failed because they failed to meet one of those elements. That is, they either did not register the domain name in bad faith, or they're not currently using it in bad faith. The usDRP is much more liberal on the bad faith element and requires only that a trademark owner show that it was registered or is being used in bad faith. There's also some additional detail on how a domain name registrant can defend itself by showing that it has rights or legitimate interest in a domain name, at least some additional detail in the policy itself. Interestingly, there's also a difference, an important difference in the language of a proceeding. Under the usDRP, the default language for a proceeding is the language of the registration agreement. That is the registration agreement under which the domain name registrant obtained its domain name. There are some exceptions to that rule, but that's the rule. usDRP proceedings, on the other hand, it's very simple. They are to be conducted in English. So this can be a significant advantage for entities that are filing a complaint that only speak the English language. One other significant difference is on the mutual jurisdiction provision. This is something that is required for every complaint and essentially specifies in what jurisdiction a trademark owner who's filing a complaint consents in the event that the domain name registrant actually files suit in court. In the usDRP, that jurisdiction is either the location of the registrar or the registrant. However, under a .us usDRP proceeding, the mutual jurisdiction is limited to a U.S. court. It's either at the location of the registrar or registrant, unless there is no U.S. court in one of those locations. That is, if the registrant is outside the U.S., but obviously is otherwise eligible to register the .us domain name, or if the registrar is outside the U.S. In those cases, simply the usDRP specifies that Virginia is the appropriate mutual jurisdiction. And then finally, while you have a choice of providers for a usDRP complaint, one of which is the forum, if you want to file a usDRP complaint, you have only one service provider, and that is the forum itself. Moving on to the second domain dispute policy that applies to the .us top-level domain. This is the usRS, or the US Rapid Suspension System. It is newer than the usDRP. Again, the usRS only allows for the temporary suspension of a problematic domain name. There have been only 5 cases since 2014. So you can see that it is certainly not a popular dispute policy. And there are a number of reasons for that I'll talk about in just a minute. The suspension that a trademark owner can obtain if it prevails in a usRS proceeding is a temporary suspension. A suspension page is displayed. I'll show an example of that in a couple of slides. for the life of the registration of the domain name or potentially for one additional year. There's a three-part test that is very similar but not identical to the usDRP. There are some sort of further restrictions on what types of trademarks are eligible for disputes under the usRS, as you can see here. But otherwise, there's that lack of rights or legitimate interests. And again, the bad faith element, the third element, like the usDRP, the usRS has that magical word "or" in it. In other words, you need to show that the domain name was registered or is being used in bad faith. Again, like the usDRP, filings are all handled online. There is a complaint and response, and that truly is it. While the usDRP allows for some exceptions to that, including supplemental filings under certain circumstances, the usRS simply does not. There's only a single examiner or panelist in a usRS proceeding. Decisions are issued much more quickly, but there's also a bit of a complicated appeals process where a losing domain name registrant has a period of time in which it can appeal within the usRS system itself that decision. I mentioned a moment ago about that interesting complication under the usDRP because the remedy typically is the transfer of the domain name. That would not be an issue in a usRS proceeding because there is no transfer of the domain name, there's just a suspension. But one potential complication, again, perhaps maybe more theoretical than actual, is a delay in enforcement of a usRS proceeding. Simply because there have been so few cases, as I mentioned a moment ago, only 5 since 2014. The registry operators themselves, and we've seen this maybe more so in URS proceedings, which apply to .com and others, including the new ccTLDs. We've seen instances in which registry operators are simply unfamiliar with their obligations, and while the suspension is supposed to take place immediately, that does not always happen. So here on this slide, we just wanted to sort of compare and contrast the URS versus the usRS. Again, just to be clear, the URS, the Uniform Rapid Suspension System, applies to the new ccTLDs. It does not, by the way, apply to .com and or most of the older ccTLDs. And the usRS applies only to the .us ccTLD. The registration and use versus registration or use is the same issue here in the URS versus the usRS. Language is also a bit of a difference because it's possible for a response in a URS proceeding to be filed in a language other than English, but under usRS proceedings, the entire proceeding is to be conducted in English. Again, you can see the same mutual jurisdiction issue as is true for the usDRP. And one significant difference as well is where a complaint under the usRS can actually be filed. Forum is the only provider of usRS services. So I said I would show what a suspension page looks like, and this is one. So this is the page that is displayed to an internet user who tries to visit a web page in which a .us domain name has been suspended. Again, this suspension page will be displayed for the life of the registration with an option for one additional year. So really, I've been talking all this time on a bit of background of .us itself and some substantive issues for the two .us dispute policies. At this time, I'd like to hand the microphone over to Renee Fossen at the forum, who will provide us with some very useful practical advice on how to actually file one of these complaints. Renee?
Thank you, Doug. Yes, to file a complaint, all of the instructions are on our website, and the link is there on the slide. The complaints may be filed via the portal for those filers that have used the portal before for maybe a usDRP complaint, you can use the portal for the usDRP as well. Or if you're not a user, you can file by email, and a case coordinator will contact you and get started helping you file your complaint. The sample forms are also available for complaints responses. There's also stay and extension and withdrawals forms available in case that arises in your case. That doesn't often happen in usDRP cases, but it does happen on occasion where parties will ask for stays or extensions, or maybe withdraw the case before it goes to a panelist for decision. So those forms are available on our website. Links are also provided for filing complaints and responses. You could just simply click on the link and it'll bring you right to the page on our filing portal to file your complaint. Additionally, there are links to the rules, the policy and rules, and our supplemental rules, which are important because that sets forth the fees that are involved in filing a case. On the next slide, this demonstrates what the online filing login page looks like. As you can see in the middle there, you can log in as a guest, or if you already have a password for our portal, you can log in there and you'll be brought to your dashboard. As far as the domain name box that's below that in the middle of the page, if it's not a .us, you'll be kicked out and instructed that you aren't able to proceed unless it is a .us, as this is the procedure that you have selected. You just fill in your information and pick a single member or three-member panel, and the fees will pop in based on what you've selected. If you had one domain name and you picked a three-member panel, the price would be $2,600, and that would pop in, and you'd be able to see that. And then there is an explanation below as to how it's calculated. Those fees can be found in our supplemental rules under paragraph 17 or rule 17, if you wanted to check those out. Moving on to the next slide, we have the portion where you'd be uploading your complaint. As I said, you could, we have sample complaints that you could fill in, or you could do your own and upload it at this point, and then you would have your annexes, which would be your supporting documentation, any registration information that you may have, proof of use, that type of information would be added as the annexes. And you can see at the top of the page there, it gives you the size limitations for the files that you would be uploading. I haven't heard many complaints about not being permitted enough space, but maybe Doug could chime in here if he's had problems with size limitations for the files, but I haven't heard of much of any complaints as far as that is concerned. Again, if you're having difficulty uploading any documents, our case coordinators will be more than happy to help assist you in that and answer any questions. The size limitations and file types are also included in our supplemental rules, which are found on our website with our link. Moving on to the next slide. This is where you would pay your fee. The preferred method for us is for you to pay by credit card, but of course you can pay by mailing your payment in or a check. If you pay by check, that may delay the commencement of the case. You will still be assigned a case number and be able to contact a case coordinator, but your case won't be able to be commenced or verified until you've received your payment. Moving on to the next slide. Once you enter your payment information, you will be assigned a case number. As you can see at the top of the page there, it's the FA. Typically, we just use the last 7 digits as the case number. It's just easier to keep track of that way. So if you do need to contact a case coordinator with questions, just use the FA, and then in this instance it would be the 1641310 number. You'd look it over and make sure that all of your information has uploaded and that your payment type is correct, and that would do it. You would print that page for your records. Moving on to the usRS. Again, there are instructions available on our website. The complaints must be filed on the portal. You can't use email for a usRS case. A link is provided for filing the complaint. Sample forms are provided for the complaints and responses, and those are the only documents that are allowed in a URS, as Doug mentioned earlier. Responses must be filed through the forms portal, with an encrypted link that would be emailed to you at the commencement of the case to a respondent to be able to respond to a complaint. Links to the policy and rules, again, and our forum supplemental rules are also on our website and are very helpful to understand the process. I would highly recommend reading that information if you haven't filed a usRS or a usRS case. They're very helpful. If you do have portal access, this is what your dashboard would look like, and you would select from the drop-down usRS over on the right side. If you aren't a registered user, you'll need to sign up, and if you need help from our case coordinators to be able to do that, they're more than happy to assist you and get you signed up with portal access. You must agree to certain terms before you can proceed. At the top there, you have to file as a complainant or a complainant representative, and the two things you'd need to agree to are the statement of good faith, that you believe in what you're saying, you believe that you have a case, basically you are saying that you have a prima facie case, and you agree to the terms for the domain dispute resolution process. As Doug mentioned earlier, there's the mutual jurisdiction boxes. You need to pick one of those. If the location of the registrar or the location of the registrant is not in the United States, then you will need to select the Commonwealth of Virginia. And I think it's pretty clearly laid out there that that would be for usRS cases only. Do not select that option if you are filing a URS case. Moving on to the next slide. Again, similar to the usDRP, you need to enter a .us domain name or domain names. You may have more than one in a particular case, but you are unable to mix and match the .coms or any other legacy or generic TLD in a case. So they must be .us. Moving on, if you've logged in as an existing user, the fields will be pre-populated here, but even if they are and you want to change some information, you can edit any pre-populated contact information. But please note that if you do that, that doesn't update your portal information if you already are assigned a user. You would need to contact a case coordinator to update your portal information, or do that outside of filing a case. If you have multiple related complainants, you can do that, but you need to click and add another. That would be the middle box at the bottom. You'll be asked to explain what the connection or link is to the first complainant. They need to be related. On the next slide, the respondent is the entity and the who is information. If you have additional information as, for instance, the counsel for the respondent, if you've had dealings with them before and you happen to have that information, this is the place where you could enter that. Moving on to the next slide. The complaint auto-generates, unlike the usDRP. You need to check the relevant boxes as to the allegations that you're going to make in your complaint. And those are pretty self-explanatory. Doug kind of went through those in his presentation on what you need to claim or what you need to prove as far as what you would include in your complaint. And you can provide an explanation of up to 500 words as to bolster your case, in addition to any information that will be uploaded. At the bottom of the next page there, you have the box for legal proceedings, and you must identify any other legal proceedings. This would be something that maybe has already commenced or is in another jurisdiction, or has terminated with the domain names that you're claiming in your case. Moving on to the next slide. For each domain name, you need to enter supporting documentation. Now, if you have a lot of domain names, this can take some time, but we haven't seen that happen a lot, especially in the 5 usRS cases that we've had. You need to upload any information that would be proof that your mark is protected by statute or treaty. That you can upload proof of use information, and a screenshot of the website. If you have difficulty uploading those documents again, feel free to contact the case coordinator and they'll help you identify that information. The following slide shows if the respondent information should automatically fill in. If it does not, you'll get a message like this, and then you may need to do some double checking and make sure that your information is correct. And if you continue to have difficulties with this portion, then you can contact a case coordinator. Moving on to the next slide. This is where you'd verify that your information is correct, that all of your information is correct, and that all of the documents that you wanted to upload have actually uploaded, and you can see the titles of those documents. Moving on to the next slide. For URS and usRS, we only have the credit card option, so you'll have to pay by credit card, unfortunately. If you also on this page need to agree that all the information you've provided is true to the best of your knowledge, and you need to click that box. And if you don't, then you can't move on, and that's always annoying when you miss those little boxes. But I think so many of us are used to them now. It's pretty common. Moving on to the next page, then you'll get a confirmation with your FA number, and it's the same thing. Typically, we just go by the last 7 digits, and we'll help you ID the case if you do have questions or concerns that you need to address. It gives you a reference number for the case coordinators. You will also be assigned a case coordinator at this point. If you have questions before the process starts, then you may have a different case coordinator that's ultimately assigned to your case. And this again would be your receipt. So that's in a nutshell how you file a case. We have a lot of helpful information on our website, and our case coordinators always return phone calls within 24 hours, or usually less time than that, unless of course it's the weekend. So I urge all users, complainants, and respondents to contact the case coordinator if you have any questions at all. Just some fun statistics for the usDRP. As Doug mentioned, it's not a very popular form of dispute resolution. We've had 610 cases filed. 6 of them were pending as of March 8th. Of those, 516 were transferred, 23 domains were denied, 3 had a split decision, which means that not all domains in the case were treated the same. Maybe one was transferred and one was not. We've had 1 cancellation and 61 have been withdrawn. Moving on to the statistics for the usRS, as Doug mentioned, we've only had 5. 1 case is pending. Of the 4 cases that were decided, suspension was ordered in all cases, but all were default determinations, meaning that the respondent did not respond to the complaint and filed no response. As you can see, it's been kind of stagnant. 2014, 1 case, 2015, 1 case, 2016, 1 case, and 2017, 2 cases so far. So a boon for the usRS this year. And with that, Doug, I'll turn it back to you.
Great, thanks, Renee. That was very helpful. And I can say that the online portal, the forum has makes it very simple to walk through the steps of filing one of these complaints. Really, one of the only complications is making sure you've got your documents and information ready to go when you do log in, and if you don't, then you can, I believe, save your filing and return to it later. Renee, you can correct me if I'm mistaken with that, but it's a very orderly process and a good way to manage the cases. So what I really just wanted to sort of summarize here before we get to some of the questions that some of the listeners have submitted is to now sort of talk about how to decide what type of complaint to file. Before, the comparisons I was making were between the .us policies and their sort of corresponding dispute policies. Here, I'm actually comparing and contrasting the 2 .us dispute policies with each other. That is the usDRP with the usRS. because there are some very significant differences between the two. And we've talked about a number of them already, and some of them we haven't. Certainly the most important difference between the usDRP and the usRS is what is the remedy. In other words, if you are a trademark owner, what desired outcome do you want to obtain? If you simply want to have a domain name suspended because you don't want it being used by the current registrant in the manner in which it's being used, or are concerned that the current registrant might use it in a manner that would be a problem, and you don't care to obtain the domain name for yourself, then the usRS may be a good option because you can get that suspension. However, if you actually want to obtain registration of the .us domain name for yourself, that is a transfer of the domain name, then the usDRP is the way to go. There is also a significant difference in the filing fee between these two policies. The fees vary depending in part on, among other things, on how many domain names are in a complaint. But as you can see, the starting prices are quite different. A usDRP complaint starts at $1,300 US, whereas a usRS complaint begins at only $375 US. So if money is a significant issue, then that may be a consideration here. Time is also very important, and a slight difference between the two. A usDRP case is resolved, it takes a little bit longer to resolve a usDRP case than it does a usRS case. The decision times that are listed here in this table refer to the amount of time that a panelist or an examiner has once it receives the case to issue its decision or determination. And as you can see, a usDRP decision comes about 14 days once that process begins, whereas a usRS determination comes with within only about 3 days. Not only that, but there are some other potential complications in the life of a usDRP proceeding that frankly don't arise in the course of a usRS proceeding that can further delay a usDRP decision. There's also a significant difference in the burden of proof. usRS cases, frankly, are presumably a bit more challenging to win, although there have been so few of them that that may be a bit of an overstatement. I am sort of thinking more really about the URS, which is its counterpart. The burden of proof for a usRS proceeding is clear and convincing evidence, whereas it seems as if the burden of proof for a usDRP proceeding is lower, perhaps only a preponderance of the evidence. There are some slight differences in the bad faith defenses, and one really important difference between the two is what do you need to say in your complaint. If you need to say a lot to make out your case, then you probably need the usDRP, because the limitation on a usDRP complaint is 15 pages, which is pretty generous, whereas you're only entitled to 500 words for a usRS complaint, which is far from generous and can be challenging to say much in that space. And that's on purpose, because the policy, the usRS, was designed really for clear-cut cases. The filings are much more rigid as well for a usRS proceeding. As Renee showed us in the portal at the forum, you can only submit 3 specific annexes in a usRS proceeding. usDRP is much more flexible and liberal, and there's really no specific limitation on the number of annexes. As I said a moment ago, there are some issues that can arise during the course of a proceeding that can slow down a usDRP proceeding. That includes the potential for supplemental filings, that is, additional filings by the complainant or the respondent, which can occur in a usDRP proceeding. They are specifically not allowed, however, in a usRS proceeding. Also, and I see clients consider this important at times, is not only what remedy do you want and how quickly do you want it and how much are you willing to spend, among other things, but what type of decision do you really care about? Do you want a detailed decision that examines the issues on the merits and really evaluates the facts of this specific case and it results in a substantive decision. If so, then you probably want to file a usDRP complaint. If you really don't care what the decision looks like, then the usRS may be appropriate because those determinations are very minimal, very brief. And as I mentioned before, there's no appeals process in the usDRP other than going to court, but there is an appeals process within the usRS system itself that allows either party to essentially seek another review of an initial decision. So these are some of the most important differences between the usRS and the usDRP, as we've said all along. Neither one of them is used terribly frequently, but given the recent increase in .us domain name registrations that we've seen, and perhaps if this continues as a trend, as perhaps the number of registrations increases, we may or may not see an increase in the number of domain name disputes filed over some of these .us domain names. So that really has been the purpose of the webinar today, and I know I'll turn the microphone over to Carol and ask Renee to rejoin the line as well, because I do believe that we received some questions from some listeners as well, and we'll be happy to address those now.
Well, thank you both to Doug and to Renee for today's program. We do have a number of questions that have been submitted, and some of them you may have answered in your presentation, but let me ask Renee, from one of the folks, is 500 words enough to describe the usRS allegations for a complaint, and what recommendations would you have to how you would organize and what points are the most important?
Thanks, Carol. I think that I haven't heard a lot of complaints, and as Doug mentioned, it is by design, but as Doug mentioned, he does not think that 500 words is enough. So I may turn that back over to him, but I think that the check boxes that you have above on our website kind of dictate kind of the things that you should highlight the most. And the documents, of course, that you're attaching will tell a story as well. So taking all that into consideration, I really think that you do need and should be able to tailor whatever those 500 words would be to make something meaningful for the panelists that will hear the case.
Yeah, I would just add that 500 words is not a lot. And so if you think you need more space than that, then the usRS is probably just not a good option. But so you really have to boil down your arguments to the bare essentials. I know when I've drafted complaints before, I'll typically write something outside of the portal in advance, see how many words it is using a word count in Microsoft Word, for example, and then really try to pare it down from there. You know, citing previous cases as precedent is certainly helpful, but that can eat up a lot of words as well. So there are some creative ways to sort of use some shorthand to minimize words and really just get it down to the bare essentials. So I would say 500 words is not much, but it can be done.
So, and that kind of brings us to the next question. It's somewhat related, but can decisions under usDRP and usRS be cited as precedents in usDRP and usRS proceedings?
That's an excellent question, and the short answer to that is yes. Again, just to be clear, the usDRP is modeled after the UDRP, and the usRS is modeled after the URS. So it is very common to cite, well, again, there have been so few usRS cases that might not be fair to talk about those, but it's very common to cite in usDRP complaints and responses UDRP decisions as precedent, and there are plenty of decisions in which panelists have actually said that given the similarities between the UDRP and the usDRP, the panels themselves will actually draw on UDRP decisions as precedent. You see this not only in the usDRP, but in some of the other ccTLD dispute policies that are modeled on the UDRP. So it certainly does happen.
Right, Renee, another question perhaps for you. How long does it take for a case to be decided? You mentioned the 3 days, but in some cases, but how long does the process, let's say, really take when you take into account perhaps needing to go back and get more information and so forth? How long does the process really take?
Yeah, I think the numbers that Doug cited before were how long once a panelist gets the case, how long they have to decide it. The process, once the case is commenced, for usRS cases, the average is 20 days from commencement to decision, and for a usDRP case, that average is 47 days. So that's kind of in line with what Doug was saying earlier about a usDRP case taking, 2 months or so. But the average that I found is 47 days, and that's right in line with URS. I think our average for URS cases is 21 days, and for UDRP, our average is 45 days. So that makes sense. They're very similar, and typically, I think that's what a filer and a respondent could expect.
Okay, that's good. Good, that's helpful.
And I would just add one quick addition to that, and Renee, correct me if I'm wrong. I think you're referring to how long it takes sort of from commencement to decision or determination. One point that maybe I failed to mention during the presentation is what happens after you get that decision or determination. And there's a slight difference between the usDRP and the usRS. If a trademark owner gets a winning decision in a usRS case, then the registry operator, I believe, is required immediately, I think that's the word, in the usRS to suspend the domain name. Whereas under the usDRP, there's actually a waiting period of, I believe it's 10 business days before the registrar is required to carry out the transfer or cancellation of the domain name.
Yes, that is correct.
Well, Doug, we had another question that's probably something for you. Are there any penalties for bad faith complaints?
Sort of. or the short answer is, I suppose, yes. The longer answer is there's, and penalty may be overstating things with respect to the usDRP. There is something called reverse domain name hijacking that parties are probably pretty familiar with from the UDRP context. Reverse domain name hijacking also applies to usDRP proceedings. I'm just pulling up the policy here itself. The definition of reverse domain name hijacking means using the policy in bad faith to attempt to deprive a registered domain name holder of a domain name. So this is essentially a finding that a usDRP panel can issue when it issues its decision. That is, whether the trademark owner complainant has engaged in reverse domain name hijacking. It is not really a penalty as such because there's no consequence even if the panel finds reverse domain name hijacking. It's a little bit of a public shaming, I suppose. The usRS, on the other hand, does not have reverse domain name hijacking, but it does have an entire section devoted to what are called abusive complaints and allows an examiner to find that a complaint was abusive under certain circumstances if it was intended to harass or cause unnecessary delay or needlessly increase the cost of doing business. An examiner can also find that a complaint contained a deliberate material falsehood. And there are real penalties, not just public shamings or slaps on the wrist, if an examiner finds that type of abuse. The usRS policy actually says that if a party is found to have filed 2 abusive complaints or 1 that has a deliberate material falsehood, then it is barred from using the usRS for 1 year. And there's even the possibility, if there are 2 findings of deliberate material falsehood, of a complainant being permanently barred from utilizing the usRS. Now, that's pretty significant, but given the few complaints and proceedings that we've had under the usRS, it's something that's pretty theoretical at this point and has not arisen in practice as far as I know.
Do we have time for a couple more questions?
I think we're about out of time, but I know that Renee and I would both be happy to receive any emails and try to answer the best we can if any listeners want to follow up with us after the webinar today.
Because we do have quite a number of questions that may need some response. I want to thank both of our presenters today for their engaging program, and if you wish to stay informed about domain name disputes and internet law, as we said, Doug Isenberg publishes a daily news alert and weekly blog. You can sign up at www.gigalaw.com/subscribe. Otherwise, this ends our program for today. And reminder that we will be sending out the evaluation form shortly, and please return those. We look forward to your comments. Otherwise, we thank you for attending, and this concludes today's program.